In the last two videos, I introduced the first principle of IDEA, Free Appropriate Public Education, also known as FAPE, and the second principle, Eligibility and Evaluation. In this video, I'll introduce the third principle of IDEA, Individualized Education Program, also known as IEP. IEP is the primary vehicle for delivery of a FAPE. School districts are responsible for organizing IEP team meetings. Parents must agree to the IEP meeting time and location. According to Code of Federal Regulations, parents can attend an IEP team meeting through video conferences and conference calls. The school districts must ensure that the parents have the opportunity to participate fully, which may require hiring foreign language translator or sign language interpreters. If no parent is available or willing to attend, school officials should document each effort to encourage parental involvement. In the case AL et al. V. Jackson County School Board 2015, a student suffered from a traumatic brain injury. Beginning in 2001, the district identified the student as a child with a disability and began providing various services to the student in order to meet the school district's duties under the IDEA. Over the years, the student's mother claimed that the school district violated the IDEA by failing to include her in the November 17, 2010 IEP development meeting, and failing to meet her demand to provide the student with an independent educational evaluation. The student's mother also complained that the school district discriminated against the student in various ways based on his disability, and also retaliated against her son after she complained about instances of discrimination. The student's mother requested a due process hearing with the Florida Division of Administrative Hearings. By the time the hearing was completed, the administrative law judge had heard from over 60 witnesses and received more than 160 exhibits. The administrative law judge denied all of the claims made by the student's mother. Regarding the claim that the school district failed to include her in the November 17, 2010 IEP development meeting, the IDEA's implementing regulations provide for instances in which a school board may conduct an IEP meeting in the absence of the parent. Specifically, a meeting may be conducted without a parent in attendance if the public agency is unable to convince the parents that they should attend. In this case, the public agency must keep a record of its attempts to arrange a mutually agreed on time and place, such as, first, detailed records of telephone calls made or attempted, and the results of those calls. Second, copies of correspondence sent to the parents and any responses received. And third, detailed records of visits made to the parent's home or place of employment and the results of those visits. So if a parent refuses to attend an IEP meeting or take actions that are equivalent to refusing to attend an IEP meeting, the school board may hold the meeting without the parent in order to develop the child's IEP. In this case, the student's mother did not explicitly refuse to attend the November 17, 2010 IEP meeting, but her actions were tantamount to refusal. The school board tried to schedule the IEP meeting over several months with notification to the student's mother so that she could participate in the process. Those attempts to schedule a meeting for the development of the student's IEP began in early August 2010 and continued through mid-November. During this period that lasted for 4 months, Despite the school board's efforts to accommodate the student's schedule and demands, the student's mother either missed or refused to consent to attending 4 separately scheduled meetings, including the last one scheduled for November 17, 2010. On that morning, the student's mother sent the school board an email indicating that she could not attend the meeting because she was sick. She once again asked the school board to reschedule the IEP meeting. Although the school principal responded that the IEP meeting would proceed as planned due to the student's urgent academic and emotional needs, the school board offered to allow the student's mother to attend the IEP meeting by telephone, as she had done in the past, but the student's mother refused this time. The school board faced the dilemma of allowing the rescheduling of IEP meeting to be continued indefinitely or proceeding with the meeting without parent participation. While parent participation in developing a child's IEP is certainly an important goal of the IDEA, in this case, the student's specific educational goals stagnated because of the student's mother's endless requests for rescheduling the meetings. The 11th Circuit held that under these circumstances, the school board did not violate the IDEA when it proceeded with the November 17, 2010 IEP meeting in the absence of the student's mother. Regarding the claim that the school district failed to meet her demand to provide the student with an independent educational evaluation, the regulation states that if an independent educational evaluation is at public expense, the criteria under which the evaluation is obtained, including the location of the evaluation and the qualifications of the examiner, must be the same as the criteria that the public agency uses when it initiates an evaluation, to the extent those criteria are consistent with the parent's right to an independent educational evaluation. When presented with a request for an independent educational evaluation, a public agency must either ensure that an independent educational evaluation is provided at public expense or file a due process complaint to request a hearing to show that its own evaluation is appropriate. In this case, in the spring of 2009, the student's mother requested an independent educational evaluation at the school district's expense. When the student's mother finally chose an evaluator, the fee was $1,500 more than the approved fee. Regardless, the school board agreed to cover the fee. Then the student's mother insisted that the evaluation be conducted by a different evaluator at a facility 200 miles away. The school board declined that demand, noting the high expense and the availability of closer, appropriate facilities. Although the student's mother agreed to have the independent educational evaluation performed by an evaluator located closer, she did not have the evaluation done. Instead, more than 2 years later, during the summer of 2012, the student's mother took her son to Colorado to be evaluated by a doctor from the facility the student's mother chose 2 years ago. It was worth noting that the evaluation appears to have been obtained for use in litigation based on the timing of the evaluation and the fact that the student's mother listed the doctor who conducted the evaluation as their expert witness during the district court proceedings. The court held that the school board took reasonable steps to ensure that an independent educational evaluation took place. The board made available an independent educational evaluation at its own expense by a qualified provider within the relevant geographic area and within monetary limits that were more than reasonable. The student mother's own actions sabotaged the independent educational evaluation process. Regarding the parents' claims of discrimination based on disability and the school district retaliating against her son after she complained about instances of discrimination, the court struck the claims because they failed to meet a 2-year statute of limitations. In case Doug C. v. Hawaii Department of Education 2013, a student was diagnosed with autism at age 2. Beginning in 5th grade, the student's IEP placed him at a private special education facility at the expense of the Department of Education. In September 2010, the IEP team and the student's father first discussed the annual IEP meeting date during a student support meeting. A special education coordinator at the local high school testified that the student's father and members of the education team all agreed that the IEP meeting would be held on October 28th. However, the student's father testified that he thought that he had only agreed tentatively to meet sometime in late October. On October 22nd, the special education coordinator called the student's father to confirm the October 28th meeting. The student's father stated that he was unavailable that day, and they settled instead on either November 4th or 5th. The student's father testified that the November date was also tentative, subject to checking his calendar and confirming. The following day, the father called the special education coordinator to let him know that he was not available on that day, and they settled firmly on November 9th instead. On the morning of November 9th, the student's father emailed the special education coordinator at 7:27 a.m. The father explained that he was sick and therefore unable to attend the IEP meeting. He suggested rescheduling the meeting for the following week on either November 16 or 17th. The annual review deadline for the student's IEP was Saturday, November 13. The special education coordinator offered to reschedule for either Wednesday, November 10th or Thursday, November 11th, accommodating the other members' schedules while still holding the meeting before the deadline. The student's father responded that he could possibly participate on either of days, but could not definitely commit to either day since he was ill and could not guarantee that he would recover in time. The special education coordinator also suggested that the student's father participate by phone or on the internet. But the student's father explained that he wanted to be physically present at his son's IEP meeting, and he did not feel physically well enough to participate meaningfully through any means that day. The special education coordinator decided to go forward with the meeting on November 9th as scheduled. He testified that he had already asked 13 people on 3 separate occasions to change their schedules and cancel other commitments to schedule the meeting. Therefore, without a firm commitment from the student's father for one of the 2 days he proposed, the special education coordinator refused to reschedule the meeting. The special education coordinator and the IEP team held the meeting without the participation of the student's father. The only staff member from the private special education facility on the IEP did not attend the meeting either. With this key participant absent, the IEP team changed the student's placement from the private special education facility to the program at the local high school. After the meeting, the special education coordinator sent the student's father the new completed IEP for his review. The team held a follow-up IEP meeting on December 7th with the student's father and a staff member from the private special education facility. At the follow-up meeting, the team reviewed the already completed IEP line by line. The special education coordinator testified that the student's father provided no substantive input, while the father explained that he rejected the IEP in its entirety because he was excluded from the development process. No changes were made to the IEP during the December 7th meeting. But the day before the follow-up IEP meeting, the father filed a request for a due process hearing as provided by the IDEA. He argued that the lack of parental participation in the IEP meeting denied his son a FAPE. The administrative hearing officer issued a decision finding that the department did not deny the students a FAPE and dismissed the parents' claim for relief. The district court affirmed the decision. The student's father appealed. However, the Ninth Circuit concluded that the Hawaii Department of Education violated the IDEA's explicit parental participation requirements. The department held the student's annual IEP meeting without parental participation, even though the student's father did not affirmatively refuse to attend, but rather actively attempted to reschedule the meeting in order to participate. By denying the parent the opportunity to participate in the IEP process, the department denied the students a FAPE. In this video, I introduced the third principle of IDEA, IEP. I used two cases to explain how courts have ruled in the cases about parents' participation in IEP. In the next video, I'll introduce the fourth principle of IDEA, least restrictive environment.